LPS has a tradition of launching debates on highly interesting and complex topics. Such is the theme proposed for this issue of the journal Weakness and Effectiveness in Law. My presentation is about weaknesses of constitutional law. Law as a social and political phenomenon is meant to ensure order in society and to contribute through appropriate regulations to its evolution in all areas. From this perspective, to avoid descending into chaos, the law must be capable of providing the best solution to society's challenges. However, the bad news is that the law is not perfect. It has its weaknesses. The law must track developments in society in response with the regulation that keep pace and direction with those changes. Yet this process is far from simple. In its course, the law's response can be delayed or only approximate, thereby bringing its weaknesses to the forefront. On the other hand, the good news is that the law possesses and indeed utilizes mechanisms of self-regulation to adapt to social and economic changes. Through suitable legislation, judicial interpretation, and recourse to fundamental legal principles, the legal system manages to maintain balance in the community. Law exhibits weaknesses across all its branches, from international law to procedural law, a point frequently noted in various studies. There are weaknesses in the regulation of certain powers, which are often insufficient or uncoordinated. There are also weaknesses in the judicial system, stemming from defective methods of appointing judges, such as a lack of transparency, political interference, and compromised judicial independence, or from inadequate training of judges. These weaknesses can have an even greater impact when combined with the absence or ineffectiveness of judicial oversight, particularly in international law. Another weakness of the legal system is inadequate regulation, whether under-regulation or conversely over-regulation, as both can impede the uniform interpretation and application of the law. These weaknesses can be further exacerbated by the Talek-Valley importation of external legal models and regulation that are sometimes alien to the society's own legal culture. These are only a few examples, but they suffice to support the conclusion that, in the face of such weaknesses, the law ceases to keep pace with the evolution of social relations. Instead, it acts more as a brake on society than a driving force. Constitutional law is no exception to this picture. In fact, its weaknesses have the most significant societal impact because constitutional law not only establishes and regulates the relationships between public institutions in a democracy, but also promotes and safeguards citizen rights. Therefore, whenever priorities are asserted in arranging fundamental rights, when protecting one right requires accepting additional limitation on the exercise of another, we are confronted with the weaknesses of constitutional law. To support this claim, I have presented in the article instances of fundamental rights coming into conflict, with special attention to the right of private, intimate, and family life. The exercise of this right is undermined on one hand by interference from the right to freedom of expression, and on the other by threats emerging from the online environment and virtual platforms. Private life versus freedom of expressions. The doctrinal and jurisprudential issues that arise concerning fundamental rights revolve around the exercise of those rights, especially the scope of their exercise. For this reason, avoiding conflicts between rights will always remain a serious challenge for any framer of a constitution. The right to intimate family and private life implies that everyone should enjoy the confidentiality of their private life, have the right to their own image respected, and not have personal data made public without explicit consent. These requirements have become increasingly difficult to uphold amid the unprecedented expansion of mass media. The media, invoking necessity and everyone's right to information, often push beyond the permissible boundaries of privacy, resulting in a collision between the right to private life and one's personal image on the one side, and freedom of expression and the public's right to information on the other. Not infrequently we hear, particularly from public figures, accusations that acts of libel or defamation have been perpetrated through the media. Likewise, journalists often complain of harassment and constraints on press freedom through lawsuits brought against them. Looking across time, if we imagine the edifice of fundamental rights, freedom of expression lies at its foundation. It belongs to the first generation of fundamental rights and freedoms championed by French Revolution, which in the Declaration of the Rights of Man and of the Citizen, la Déclaration des droits de l'homme et du citoyen, proclaimed the freedom to communicate thoughts and opinions as one of the most valuable human rights. Human freedom can be understood in two dimensions, one physical and the other pertaining to conscience. Thus, the French Revolutionary, in the first articles of the Rights Charter, proclaimed the physical liberty of the individual, followed immediately by the affirmation of freedom of conscience and freedom of expressions. However, the exercise of the right to free expression is not absolute. A first limitation is, of course, the obligation not to cause harm to others, allowing each person to enjoy their own rights. A significant and essential limitation on freedom of expression is that it must not prejudice a person's dignity, honor, private life, or the right to their own image. Especially in the period after the Second World War, human dignity has emerged as a decisive principle in many situations, tipping the balance when different interests collide by giving precedence to the interest that upholds human dignity. When it comes to freedom of expression via the mass media, it must be noted that this freedom comes with obligations and responsibilities. The guarantees provided to journalists under Article 10 of the European Convention on Human Rights are contingent on journalists acting in good faith, providing accurate and credible information while respecting journalistic ethics. At times, under banner of necessity and the public's right to know, the permissible limits of privacy are breached. Public figures especially complain of slanderous allegations laid against them in the media, just as journalists complain of harassment and curtailment of press freedom through lawsuits filed against them. This reaction seems to suggest a collision of two sets of rights. On the one hand, the right to private life and to one's own image. On the other, freedom of expression and the right to information. Legal doctrine speaks of a conflict of rights. when the obligation necessary to fully realize two or more rights cannot be satisfied simultaneously because the fulfillment of one would nullify the other. Such a situation may occur when what one right demands is forbidden by another right, or when two rights impose different obligations that cannot be met at the same time. In the case of supposed collision between the private life and personal image versus freedom of expression and the right to information, we can conclude that this is not truly a clash of rights at all, but rather an abusive exercise of rights. It is an abuse of the right to one's image when, under this shelter, someone attempts to cover up and silence various illegalities. It is an abuse of freedom of expression when it is employed either to knowingly circulate falsehood about a person or to violate that sphere of intimacy which every individual is entitled to enjoy. Private life versus personal security. The restriction of personal rights in the name of collective rights or public interest, such as national security, public order, or crime prevention, has always been a sensitive matter of regulation. It necessitates maintaining a just balance between individual rights and interests at one hand and the interests of society on the other. The question of how constitutional law can safeguard the right to private law took on new urgency after the terrorist attack of September 11, 2001 in New York. In its wake, a series of measures were adopted worldwide to prevent similar events. All of these measures dealt primarily with monitoring citizens' daily activities and storing information about them. Romanian legislation on the retention of data generated or processed by public electronic communication network providers and electronic communication service providers transposes Directive 24 of March 15, 2006 of the European Parliament and of the Council, adopted following the terrorist attacks of July 7, 2005 in London. Directive 24 came under scrutiny by the judges in Luxembourg after two preliminary questions were referred to them in 2012 by the High Court of Ireland and the Constitutional Court of Austria. In its judgment of 8 April 2014, the Court of Justice of the European Union ruled that Directive 24 violated the provision of Articles 7, 8 and 52, paragraph 1 of the Charter of Fundamental Rights of the European Union. The Court of Justice based its reasoning on the relationship between the contested directive and the provision of the Charter of Fundamental Rights of the European Union, finding that the retention of the data in question was compatible with the Charter. However, the measures provided for in the directive constitute an interference with rights guaranteed by Article 7 and 8 of the Charter, in breach of the principle of proportionality between the measure taken and the public interest protected. The Court noted in this regard that the data covered by the directive lead to very precise conclusions about the private lives of the person whose data have been stored, which may concern their daily habits, their permanent or temporary places of residence, their daily movements, their activities, the social relationship of those persons, and the social circles they frequent. Romania's Constitutional Court had actually confronted the data retention issue earlier in decision number 1258 of October 8, 2009, which reviewed the constitutionality of the domestic data retention law. The Constitutional Court observed that the law's provisions fail to clearly and unambiguously define the term related data. This lack of precise legal definition to delineate exactly which data were necessary for identifying users opened the door to potential abuse in the retention, processing, and use of data stored by the service providers. Furthermore, the court emphasized that any restriction of the exercise of the right to private life and the secrecy of correspondence, as well as freedom of expression, must be implemented in a clear, foreseeable, and unambiguous manner in order to eliminate as far as possible the risk of arbitrariness or abuse by authorities. The court found similarly ambiguous wording in a provision that allowed state bodies responsible for preventing and counting threats to national security to access data retained by communication service providers. Since the law did not define clearly what constitute threats to national security, it will be possible for various ordinary actions, information, or routine activities of individuals or entities to be arbitrarily deemed as such threats. Moreover, individuals could be classified as suspects without a knowledge and without any chance to prevent the consequences of the law's application to their own conduct. In this way, a person who is merely the recipient of a telephone call could be subjected to data retention about a private life without any action or choice on their part, solely due to the caller's behavior, which the recipient cannot control. Also, the recipient is a passive party in the communication. They could unwittingly become a suspect under the stringent condition in which state authorities carry out criminal investigation. In the Constitutional Court's view, such an arrangement made the intrusions into an individual's private life excessive. Private life versus the online and virtual environment. We must also consider the new modalities of exercising freedom of expression and communication in the online environment and on virtual platforms. These new realities has led to the articulation of a new right for citizens, the right to be forgotten or right to erasure, as part of the broader framework of personal data protection. Individuals have the right, under certain conditions, to request search engines to remove links to the personal information about them when those informations are inaccurate, inadequate, irrelevant, or excessive in relation to the purpose of data processing. The right to be forgotten is not absolute. It must be balanced against other fundamental rights like freedom of expression. For this reason, decisions on delisting are made case by case, considering factors such as the type of information, its sensitivity with respect to private life, and the public interest in accessing that information. The role a person plays in public life can also be an important factor. It is evident, however, that this remedy has limited effectiveness, as some publications have simply reposted information that was delisted, thereby reintroducing it into the online sphere. On a related note, the events involving Facebook in 2018, namely the Cambridge Analytica scandal, and the manipulation of citizens via social media, which resurfaced dramatically during Romania's December 2024 presidential election, will change how the right to privacy is viewed and protected going forward. It stands as a lesson that no future constitutional framework will be able to ignore. In summary, the question that arises is, should general communal security be given precedence whenever there is even a mere suspicion of a threat, at the cost of relinquishing essential elements of personal freedom that have been secured through centuries of effort and sacrifice? Or must personal freedom be preserved as the supreme value, even at the risk of any sacrifice? To put it even more simply, is individual freedom a greater value than personal safety and collective security? This dilemma tends to split peoples into two polarized camps. Good faith defenders of liberty end up being portrayed as accomplices of the terrorists who threatened the free and democratic world. Conversely, those who absolutize societal security are suspected of seeking, whatever consciously or not, to regiment society and to transform individual freedom from a natural right into a privilege granted by those who control society. Since both freedom and individual safety are attributes of each of us, it becomes increasingly clear that we are in the position of Buridan's donkey, forced to choose between two things that are equally necessary and inalienable, with a prospect of ultimately losing both.